Hello, folks. This is continuation of document 279, 439 pages. Continue with exhibit 31, which is an email to Lisa Nishimura from Benjamin Kotner. I'm glad you said that about the end of 6. I was on the fence about it. It feels very speculative, and I don't think that every delivered enough of Silver Bolt to be able to make the directive claim about Link. I agree with your points. In particular, I need to have music do some heavy lifting to help keep us engaged in these far more dense courtroom episodes. Macro question on music. Do you discuss on call last week whether what we were hearing is final sound design or they're planning to have someone come in and refine after picture look? A few additional points. Episode 5, I like the addition and use of music under Bobby Assie's testimony. When he says, I saw Teresa walk towards Steven's trailer, I don't know what I saw. Then use the method again. However, given the density of the testimony footage, it would be good technique to further employ. Ronnie Hilliger's testimony of Fassbender testimony when he admits that he did not question Scott, the roommate. New footage of Kratz further on his heels in the press conference post Ronnie Hilliger's testimony. Much more abridged interview with Dolores and Alan after the Bobby Assie testimony section is far more effective. See, this is just giving them notes on to add music and not telling them to change anything. I wonder why that was redacted. Job sexual assault charges against Stephen Avery. Episode 5, detail. These are just footnotes on what takes place in each episode. Exhibit 33, we have another email. Marjan Javadi to Adam Del Deo. Episode 1 and 2 for murder. Place these in murder notes. Let me know if you have any questions. Need a great opening title sequence. Opening title sequence should be at least 84 minutes. Better balance that rhythm. Some scenes feels cut short. Others go on a little too long. I need to elevated approach to this. Currently feels novice at best, not expert. Title at the beginning. Currently, yeah. Once we meet Senator Morris, we should turn using transitional device Democrat that moving into a new section of story. Find the time code. Parentheses. We should perhaps use a tape deck when we are hearing Stephen Avery talk throughout the series. It should be stylized tape deck, something that is unique and interesting for the project. Says he's upset with her and he's spreading rumors about him. 8:30, do we have any great family pictures of Avery here? Let's make them look like a very happy family. Music of week over Trish Hotbox Mother. Feel like it would be better. Exhibit 34. Another email. It's worth investigating and confirming that not only has the EDTA test not been used since OJ, but also that no count has admitted the testing methodology since the use here for Stephen Avery. Not sure if it's true, but curious if you feel it's worth making this point. The episode is for sure a factual slow without any singular smoking gun, but the evidence and testimony is so overwhelming, disconcerting, that I believe that additive additive effect that will be powerful in pushing the narrative forward regarding police bias. Do you want to put the notes together? I'm not sure, Adam, if the connectivity of the flight doesn't get into until later this afternoon. Thanks. To cut 2-3 minutes out of every little bit helps. This is a bridge episode. It really covers a lot of the weaker arguments. Key falling on the floor, police log, access to clerk's office, EDTA. So it's a lot of information, and it's important without any real smoking guns. As a result of probably the most dry episode, I'm not sure there's any getting around it at this point. Here are my few little notes. 2020 music here for distinctly Western sound that sounds out a little bit. 30 minutes. I still think a simple timeline graphic listing the times related to the police log would help the scene along a lot. Just listening, time and log, blah, yada, yada, yada. Add music right here. Lisa Numera to Cotner and somebody else. We just knew we added a comment to work in progress, making a murder. What Walter Kelly is saying about the AG's report is very interesting, but he is very slow. Yeah, we read this already. 36. Jerry Breen doing contextual summary after Kraft's opening remarks feels forced when providing cut this interview. If we know the verdict is going to be read, do we need to see people reporting or running into the court? Feels redundant. Use one or the other. The reading of Steve Raimi's guilty verdict feels slow and anticlimactic. The non-musical and low-key nature of currently is too subtle and impactful enough. After the verdict, the press conference really drags on, as well as Jerry's conversation with Steven's parents. These sleazy bastards get away with it. Civil rights lawyer says this, but it feels very subjective. Music doesn't work. Good running time. Strong editing. Kaylee Dassey courtroom scene. Cutaways to news footage showing the specifics of the murder. Work well. Graphic when Brendan is describing where everyone lives might work well. Also, timeline that Brendan maps out is very important to add when Brendan is on the stand explaining why he does what he does when he arrives home from school. Need a good graphic that can show the Rashomon timelines. Gets the girls' descriptions of murdering. Does it match with Brendan's testimony? Also, separate of the writing that Kiss the Girls, are there images? Let's discuss. Add suspense music when everyone is scrambling to get into the courtroom. Andrew Colborn is there again. Maybe worth IDing him. Was the trial held given that it was a Madison jury? And a suspense beat the ID tag sentencing, just so they're clear. Episode 10, what Kratz letter says, tough to say. Lose Pete Bates in episode 10. Also lose Pete Bates overall. Cut out the trim current girlfriend, Sandy, and his mother. Too slow to look to trim if possible. Also, subsequent scene of Steven's girlfriend only be weak could probably lose all well. 53 minutes in, slack key guitar needs to be replaced. So sleepy. Totally not right. Already? 37. Thank you for visiting FFI on the past Wednesday to discuss the status of the action steps going forward. Let me make this a little bigger. Thank you for visiting FFI past Wednesday to discuss the status of the action step going forward in making a murder. The meeting was very informative and helpful. This email is intended to recap our discussion. There will be 8 episodes between 45 and 60 minutes in length, most anticipated around approximately 60 minutes. Correct. All 8 episodes currently have written outlines which have been approved by Netflix. Correct. Episode 1 through 3 are at what we might call the director's cut stage without having any post done. Correct. While no additional photography is absolutely necessary, the directors wish to shoot some more establishing type footage and other embellishments. If there's a material developments in the case, I would also be desirable to shoot additional footage depicting those events. We will discuss the shooting plans, the directors, and let us know current plans. Uh, none of this really is important to me. This is just them telling them how to structure Frank Isaac. So they blurred out his name at the top and then they accrue his name at the bottom. I don't understand. What's the point of redacting something if you're going to leave it in at the bottom? Alright, we got an email. Respect the first bullet point. I don't know how offhand the documents that Mr. Colborn may have had in mind. If we identify documents that fit that description, we will advise. With respect to the second bullet point, I'm not certain what Mr. Colborn may have been attempting to describe, but independently of his testimony, we are aware of the communications between the parties regarding a visit by Netflix representatives in Chrome Editing Studio. Although my recollection is that those were deposed claimed to have little, if any, recollection of the events at the visit, there may be a reasonable inference that could be drawn. We would have to give this further consideration before we would formally supplement interrogatory responses on this point. However, I do not know the answer with respect to the possible list of phone numbers, and I will have to look into that. With respect to the last two bullet points, I believe that we have now been provided those documents, and they will be Bates stamped and produced shortly. During Mr. Colborn's deposition, he testified about a number of documents he either said he had previously seen or which he had provided to you. We have searched for the documents, but do not believe they were ever produced to us. We note during Mr. Colborn's deposition, we would request that you please promptly produce these documents as they are clearly relevant to the litigation based on Mr. Colborn's deposition testimony. These documents are Volume 1, TR 183-19-1846. Mr. Colborn testified that he believes he's been seen documents that did say that Netflix employees had a few transcripts of the criminal trial of Mr. Avery. We believe Mr. Colborn is mistaken, but the extent of such documents exist. We would request that you produce them to us, supplemental Mr. Colborn's discovery responses to identify them. To the extent the documents were produced in the litigation by Netflix to produce defendants, Mr. Colborn testified that he believes that my attorneys do have evidence that Netflix employees did view both civil and criminal video of my testifying before, both in deposition and in Avery's criminal trial for the murder of Teresa Halbach, but was not sure whether that was raw footage or edited footage. The filmmakers provided to Netflix. We do not believe any evidence that Netflix viewed or even reviewed raw footage exists, but the extent you have such evidence would request that you produce it to us, supplement to Mr. Colborn's discovery responses to identify them, and the extent the documents were produced in the litigation and by Netflix produced to the defendants. Mr. Colborn testified that provided a list of phone numbers, including overseas numbers, for the anonymous calls he received. While we received recordings of 89 voicemails, we did not have any such list. If it exists, we request you produce it to us. Mr. Colborn testified that he printed out an email to my counsel the Facebook posts and comments of the individual who ran for mayor for the city of Green Bay, which he posted about Mr. Colborn, and Mr. Colborn escorted the individual to the NICU. We would request that you produce those documents to us. Mr. Colborn testified about an article by or involving Scotland Yard in which members of the investigative agency were interviewed and stated that Mr. Colborn planted evidence. He testified that he may have provided his counsel with the article, but if not, that he would search for the article, and then if it existed, he would provide it to us. We would request that you produce the article to us to extend its exist. Please let us know when we can expect to receive these, or there any need for parties to discuss. Exhibit 39. Deposition of Mary Manhart, held at the offices of Vertex, 7 Times Square, New York, New York, pursuant to subpoena and notice before Robert Collins, registered professional reporter. Again, it starts at page 153, not page 1. Yes, okay. The Miles Scanning 2007-15 Stephen case file pulls for you. Do you see that? Yes. What is your understanding that was referenced in civil case file materials? Mr. Vick, objection, lacks foundation, calls for speculation. I have no idea, but again, because might have been any, I don't know, post-conviction stuff. I really don't have a clue, but it was for 8 that became 10. I'm just trying to figure out how much of the various court file materials you reviewed with respect to various cases. What do you recall? Strike that. Do you recall having, for example, for the Avery civil case, access to all the case file materials that were obtained to the civil case clerk? No, if I were to go through all that stuff, we'd still be editing. It was that it's outside the editor's purview. I will say, however, then anytime I had a question about chronology, Laura brought it in all. Confidential deposition of Brendan Schuler. Oh, this. Okay. And you believe Brendan Dassey is a guilty man, a different capacity, but yes. And you believe that Mr. Colborn is an innocent man and that he did not plant evidence to frame them, correct? Correct. And you think that the making of murder and Kathleen Zellner and Strang Beauty and Mr. Farrick have all defamed Mr. Colborn, correct? Some more than others, yes. Miss Barker objects to foundation. And you said all these things pretty publicly, including on Twitter, correct? Yes, yes. And I believe you testify that you were able to create a fair and accurate, transparent documentary despite your personal beliefs, correct? Yes, yes. And despite that, I think we could call a pretty clear bias. You believe convicting a murderer will be fair and accurate and transparent? I do. And you would agree with me that a person's bias of preconceived notions don't necessarily make a documentary unfair, correct? Objection to foundation, incomplete, hypothetical. Could you say that again? Can you read it back? I just want to think about it. I want to think about that for a second, how you said that. No, I agree. You agree. I agree that that doesn't make it unfair because they have a bias. No, correct. And I think you'll agree with me that there's nothing unethical or irresponsible about making a documentary that has a point of view of protagonist. Do you agree? I agree. Same objection. Do you think there's anything unethical about the documentary that tries to persuade viewers to come to a certain conclusion? It depends, but if it just takes a minute to confirm that I could skip. Okay, it went from 220. Let me ask you if you're worried about the defamation suit being filed against you when the documentary comes out. Kathleen Zellner by the filmmakers making a murder by attorneys, Beauty and Strang. Is that something that keeps you up at night? No. Why not? Because I'm not doing anything to defame them. I'm not saying anything about them that is factual that I can't support. And I'm still going to ask a serious question. Sir, I think I know the answer to all of them, but I just want to get it out to the record. Sure. So given what you said, you would agree that even though conviction of murder may ultimately take a side, that is not grounds for a lawsuit? Mr. Kurt's objection, incomplete, hypothetical. And vague, objection calls for a legal conclusion. Okay. Can you answer if you understand the question? I'm so bad at remembering these. Can you read it back? Like, he just asked you the damn question, and now you don't remember? Like, okay. Can you read it back? Why they object? Sorry, agree. Just because it's dramatic or suspenseful or has cliffhangers or has music, that's not grounds for a lawsuit. Agreed. Same objection. Just because it strives to only inform but to entertain and engage, that's not grounds for a lawsuit. Same objection. That's hard to answer because it depends on what you're doing to entertain the viewer. If it's accurate, I can rephrase. All right, now it is state of Wisconsin. Just her notary signing it. Well, it seems I'm still gonna have to request these depositions in full. Exhibit 41, Exhibit 42 has been filed under restriction. 43 under restriction. 44. Now, this just pisses me off because I had to pay for this fucking little piece of Exhibit 44. Every one of them. So that's 30 cents I just lost for no reason. Brenda, okay. These are text messages. Brenda, I gave my old attorney a hard copy of every article Farrick wrote about me. They're all in the box I turned over to you after she was elected as judge. Maybe we can meet sometime soon and give me those, which I will then turn over to Mike. Those and what you find on the internet should certainly give Mike plenty of evidence. I also know he likes to bash MTSO and me on Twitter if you have any of those. Oh yes, I'll collect those too. I sent this because I see Mike is asking you about that on an email today. You all have all those hard copies, right? No, I shredded them. Just kidding. Of course, you silly guy. They're all nice and best in blinders for you. I'm going to visit Candy next week. Is that soon enough? Yes, the 25th through the 27th next week for sure, right? Now breakfast or lunch is on me. My kids will be here until the AM, the 26th. You let me know what works. Otherwise, the 28th, I'm off 5 days. If it helps, Friday 28th works, blah, blah, blah. Friday 28th, maybe we can all go to dinner again, and soon enough to take that to Mike and send him pics. In the meantime, let's plan on it between the links and pics you send me, and I'm hopes they will be sufficient until then. Farrick has a lot of his crap online. I have done it, sent a note to Tom and Kathy too. Brad and I are open, so plan on a 4. At least that night we will come to you, though. Sounds great. Have you been Boudin's tweet? I haven't, but I would guess he wasn't very supportive, or did he back off? I wonder if Farrick knows what's coming. If he does, he will be yanking stuff down, so I'm glad we have hard copy. David Milligan and Jerome Boudin tweet. Hope suit survives motion to dismiss and goes to wide open civil discovery. I remember this tweet. Michael Griesbach, please do depots at AC and Ken Kratz on pay-per-view. Millions will have watched. It definitely won't repair any Manitowoc County reputations, but will help retired taxpayers' debt from Stephen Avery's coming suit. The family not supportive of that too. I wish we hold him accountable for his lies. The guy is a dickhead. As bad as Farrick. Didn't even spell his name right. Or Fairhack. Oh, so they're making fun of him now. 2 peas in the same pod for sure. The pastor of my church and pretty much everyone who was at our voters meeting tonight wanted me to tell you how much they support our decision to do this, and the pastor told me we will be able to, in his prayers, thought it would be like right now. Oh, thanks so much. That's wonderful to hear. You betcha. Nice to have the support of the church. People seem happy about what we are doing. Sean sent me his text. Coverage seems pretty straightforward, and even right now, he seems a little least objective now. Better news. Hey, quick question. This shows that you had off on the 4th, 5th, and 6th of October. You didn't work Friday, but you were called in Saturday and Sunday. Is that the schedule and it doesn't get updated since it's just a schedule? Any variances to that would just show on the timesheet, such as being called in or Saturday, Sunday? That stupid-ass Andy rookie thinks he's so smart by pretending this schedule doesn't match our testimony. That schedule should be for the November, not October. I had to fill it out a 2-week time card as well. You have to the time card and all that stuff. I gave you the from my attorney. Also shows I was off the 4th, 5th, 6th of November, and I wrote in the time for 5th and 6th when I worked on scheduled days off. Exactly what I thought. Thanks much. You betcha. Those are only the schedules. Do you know when you're working and when you're off? Deputies filled out a time card daily. Sergeant and above filled out a 2-week time card, and it was encompassed the entire 2-week pay period. Fools. They just keep giving us more evidence to use. Sean sent you this. Coverage seems pretty straightforward, and even right now. Out of the blue, I'm hoping he calls you. I think he feels better knowing you're still in. Exhibit 45. from from to Barb to from Andy Colborn, from John Mayer to Michael Griesbach. Funding the lawsuit is a real obstacle, so I do not wish to pretend otherwise. I want to be clear so no one is hurt because of dashed expectations, etc. I'm willing to sacrifice my time, but fronting the cost is not something I am crazy about. Frankly, neither are my partners. None of us have any idea how far this case will go and what it will take other than to say the potential costs are enormous. So I think we get it filed and see what kind of response we get. It would be surprised if the defense did anything other than send the message that we are digging in. I am very skeptical of the idea that any meaningful responses will be made. As a person that has defended many hundreds of cases, I think I am in a decent position to offer some prognostication. Yeah, that word. This case isn't like a personal injury case where an insurer knows it will likely pay, so they should try to save defense costs by getting it done early. In addition, you have a wide variety of other factors at play here. I hope I am surprised. I would love to be wrong on that issue. Anyway, the point is that I want to be able to preserve my option to get out of any time I feel for whatever reason. If continuing to prosecute the case poses a problem in my mind, then I want to be free to say I am done. So the agreement we sign will have the appropriate language. I have already had questions from my partners about the costs involved. If we can't get funding for a significant portion of our costs, then the future of this lawsuit is at stake. I'm willing to put my time and energy in, and I would probably put some costs in, but this is a David versus Goliath battle, and anyone that represents or fights institutional clients knows they can outspend us many times over, and that is to believe that that's the way they need to do. They will likely do it. I doubt that Netflix would think for $500,000 or $1 million is a big deal for a defense cost. What we are doing is going to go to the heart of what they do. They will do what they need to do to preserve their stream of income. Our big card to play is the venue in Wisconsin. Perhaps I'm repeating myself, but the better than wondering if I was clear. Thanks, John. See this for complete trial transcript. There are more excellent info here. The MAM transcripts were also online when I wrote my book, but I can't find them. They may have been removed. Andy, I'm sure Brenda will have them. Could you ask her to forward them to you and then send them both to me and John? John, I think you have hit the nail on the head here. Our problem, a defamation claim, and how the sermon it. Even if the defamation claim is bounced on summary judgment, I don't see how the negligence infliction of emotional distress would not survive. I posted this a while back on Reddit. It's what we all hear by Reddit, making a murder comments, Ricardi, interesting word choice. Can anyone get me a trial transcript? I need a depo transcript and a transcript of the MAM film. Gentlemen, I did some research, ref my transcript and video recording of my deposition in the Avery civil case against Manitowoc County. Those are not available online in their entirety. They are available to any attorney doing litigation on my behalf, if I believe free of charge, from a company called Manuscript. Contact person Jeff Joseph, 414-362-5450. They are available in the general public for purchase as well. USA Today reporter John Farrick did buy them all, but only put 5 minutes of the testimony online designed to show me in the worst possible light. Speaking of John Farrick, would you both consider making him part of your civil conspiracy? He also knows what he printed in the Post-Crescent and the USA Today, as well as the current paper, the Joliet Patch, and was in his faults yet he continues to do it. He has now written a biography of Kathleen Zellner entitled Wrecking Crew. If you Google my name, hundreds of entirely false and or negative articles about me come up. Despite numerous contacts with the employer, they continue to say that Making a Murder and the Avery case belong to John Farrick, and clearly he is working with MAM and the Averys. He was on scene several times during the filming of MAM and is clearly assisting in any way of his paper can. 46. This is what I sent to make Mike to Sam. I hope this didn't thick him off, but Farrick has to held responsible. I was promoted from deputy to sergeant in 2003. I was a sergeant until 2011 when I was promoted to detective lieutenant. Mike, we got to talk about Farrick. This is just going to work unless we include Farrick and his publisher right away. I would refer to you on Gannett, but we can do this without including Farrick or the publisher. Could you give me the dates we worked to patrol sergeant MTSO, if not the months, at least the years? Thank you. Exhibit 47. Somebody sent something to Michael Griesbach. It's redacted. We talked about it, Andy, me, and another lawyer who was almost on board a month ago. I love to sue Buting, but it's a very bad idea strategically, even though it would defeat federal jurisdiction. Can't further explain now. I wish we could sue his slandering ass too. Yeah, he's an asshole, more than the same. But we should keep track of whether, if said about our lawsuit by Buting, Zellner, and Randy. Andy, Brenda, I will handle this. You don't need more of this bullshit. You've had enough. Until I get to the download and emails to it, I'll give you just a gist, but it's the same old, same old. He says it's frivolous. Mike has never done a civil case, and the reason he probably went with you is because possible other attorneys turned Andy down. He states that the making of murder is really just regurgitating what the defense did, and Andy and Jim were already under the microscope back during the trial days. He also said the discovery and depositions put open up a lot more information, but they didn't have access to. He brought up the license plates and a couple other things, so basically supporting that Andy did plant evidence. That's as far as I got before I stopped listening, but I did notice that he really seemed to be thinking about what he was saying before he said it, but he was clearly defending the filmmakers and Netflix, saying basically that they shared the information. I feel like these people are completely ignoring the fact that this was a rigorous editing, and it just makes me believe that no one really has any idea how much editing, deceptive editing, was done, that we are all excited about it because we were able to show them any major detail, all the edits that I have done, and it's pretty clear that deceptive, intentional, and malicious. Mike and Andy, I'm going to send you some examples, just some copy and paste to give me, you guys, what they did, and I'll send a separate email. Andy sent me a link to an interview Buting did about our lawsuit, but I couldn't get to the audio to work even though I downloaded Adobe Flash. I tried finding it somewhere else online without luck. Any other source either you can think of? It's not. Does anyone know what I said? Check YouTube, buddy. Check YouTube. Exhibit 48. Plaintiff's response to Venomous Crow Media's first set of interrogatories. Plaintiff Andrew Colborn by thru and his attorneys Longford, Conway, Blanchett, and Jerry responds to defendant Crow Media's LLC first set of interrogatories as follows. To the extent that any interrogatory is called information which is protected by the attorney-client privilege, work product, doctrine, or otherwise immune from discovery, plaintiff hereby objects to furnishing any such information not to be provided. To the extent that the interrogatories go beyond the scope, plaintiff objects and will comply only to the extent of obligations set forth herein. Plaintiff also objects to wording the defendant's request on the basis of Wisconsin law requires defamatory broadcasts be considered in their entirety, not just a collection of alleged separate statements. The entire MAM broadcast must be considered with respect to their falsity, the defendant's knowledge of the falsity, and reckless disregard of the truth. With respect to the broadcast, plaintiff objects to the interrogatories to the extent they suggest or imply otherwise. Discovery and investigation and continuing the matter of the plaintiff reserves the right to amend or supplement these responses accordingly. In addition, plaintiff's counsel only just been able to format, produce raw footage, viewable format, and not had the opportunity to view it. And again, plaintiff reserves the right to supplement his response accordingly. Subject to the foregoing objections, specific objections asserted below, Plaintiff respectfully submits without any way conceding relevancy or admissibility the following responses to the interrogatories. Interrogatory 1. Identify with specifically all spliced admitted portions of the plaintiff trial testimony as set forth in Exhibit A and B that you contend distort the facts, the nature of the 94-95 telephone call, and led viewers to falsely conclude that plaintiff bears responsibility for 7 to 8 Avery's 18 years of wrongful imprisonment. Okay, now Colborn says that he just took the phone call and then passed it on to the detectives. So why in the fuck is he filing a fucking report the day after Stephen Avery's fucking released if he just passed on the information? I hope this goes to trial. Subject to plaintiff's general objections, plaintiff refers to the summaries attached to the chart from here to. Discovery and investigation are ongoing. The plaintiff reserves the right to a supplemental response accordingly. Interrogatory number 2. For each spliced admitted portion, identify in the response integrity number 1. State how they spliced the admitted portion, distorted the facts, the nature of the 94-95 telephone call. Let the viewers to falsify conclude the plaintiff bears responsibility for 7 or 8 of Avery's 18 years of wrongful conviction and imprisonment, providing him, Colborn, with the motive to frame Avery for Hallbach's murder as alleged in paragraph 27 of the Second Amendment complaint. Subject to plaintiff's general objections, plaintiff refers to the summaries attached to the chart. Hereto, discovery and investigation is ongoing. Plaintiff reserves the right to supplement his response accordingly. Describe in detail all facts that you contend support your allegation in paragraph 33, Second Amendment complaint defenses knew of. Falsifiability in Stephen Avery's criminal attorney's suggestion the plaintiff was looking directly at Hallbach's vehicle when he called dispatch. In his response, subject to plaintiff's general objections, plaintiff responds as follows. Plaintiff testimony at civil trial regarding the call that made the dispatch responsible and credible, and specifically denied that he was looking at Hallbach's vehicle during his testimony. In addition, upon information and belief, the defendants had reviewed Avery trial court decision and order dated January 30, 2007, which explained that any theory regarding any alleged involvement in plaintiff's planting of Avery's blood in Hallbach's vehicle was extremely weak and rested on explained contradiction. As pointed out by the state in oral argument, how could Lincoln Colborn have known that Teresa Hallbach was dead at the time they are alleged to have planted the defendant's blood in their vehicle? Under the defendant's theory, either Link or Colborn or both would have formulated a plan involving their own commission of serious felonies, executed the plan within a very short period of time, motivated apparently only by their embarrassment for not allegedly having acted more responsible on the information that have led to Mr. Avery's exoneration back in 1995 or 1996. Decision in order at page 11. It was only due to the extremely low bar for the criminal defense by law to attempt to offer theories to attempt to exculpate themselves that the theory was even allowed to be presented by the judge. Under any common sense or reasonable standard, the assertion that the plaintiff had found Hallbach's vehicle prior to the time that she was known to have been deceased was obviously false. Then why does the Manitowoc Sheriff's Office have her car being listed as in their possession on November 3rd? Nothing in this case makes any sense even more. Defendants are educated persons, both have advanced degrees. In addition, Ms. Riccardi has a law degree and practiced law for some time after graduation. Accordingly, it is responsible to infer that both Riccardi and Domos knew that there was no reasonable basis to believe that plaintiff planted blood in Avery's car, that any theories to the contrary bordered on the fantastic and plaintively ludicrous, and therefore they knew they were false. Interrogatory number 4. Describe in detail all facts you contend support your allegation in paragraph 40 of the Second Amendment complaint. Defendants manipulated facts and convenience viewers to MTSO officers, possibly plaintiff, secreted Avery's blood from vial, still kept in evidence from wrongful conviction case, and planted in Hallbach's car. Subject to plaintiff's general objections, plaintiff responds as follows. The facts support the allegation the defendants have manipulated the facts. In question, are set forth in the remainder of paragraph 40 of the Second Amendment complaint. Upon information and belief, defendants have reviewed the Avery trial court's decision in order dated January 30th, 2007, in which the court noted that the fact that the state intended presented evidence that the hole in blood vial stopper had been created by phlebotomist and withdrew Mr. Avery's blood on January 2nd, 1996. Describe in detail all the facts that contend support your allegation in paragraph 64 of the Second Amendment complaint. The challenge statement intended to harm you actually irreparably harmed and damaged your reputation, lowering your estimation of the community, and subjecting you to hostility, hatred, and ridicule, and deterring third persons from associating or dealing with you. Subject to plaintiff's general objections, plaintiff responds as follows. Plaintiff counsel will be producing copies of numerous records of voicemails plaintiff received, threatening and verbal abusive MAM viewers across the world. The plaintiff designates those documents in response to the interrogatory. Plaintiff's counsel will also be producing copies of email messages and online posts to the same effect. In addition, plaintiff will testify regarding countless telephone calls he received as a personal residence and at work that were not recorded. Well, if they're at work, they were recorded. Everything is recorded at the sheriff's department, as long as it's on landline. Due to the intense verbal abuse that the plaintiff suffered the public at large following the MAM broadcast, plaintiff eventually resigned from the sheriff's department early than intended. In addition, the effect of abuse the plaintiff has contributed to the demise of the plaintiff's marriage of multiple decades. Plaintiff also incorporates the response to Integrity 8 below. Damages are ongoing. Plaintiff reserves the right to a supplemental response and discovery. Investigate continue. For each of the challenge statements, describes in detail all facts that you contend support your allegation. The producer defendants published that challenge statement with knowledge of the falsity of the reckless disregard of their truth and falsity. Number 6, response. Subject to plaintiff's general objections, plaintiff refers to summaries attached in the chart from here to. Number 7, for each material fact that alleged was omitted from making a murder, it states that the omitted fact and describe it in detail. While you believe that the producer defendants had knowledge of the omission of the fact would cause making a murder to be false, or the producer defendants omitted the fact or reckless disregard of the serious truth or falsity. Response. Subject to plaintiff's general objections, plaintiff refers to summaries attached in the chart from here to an allegation in specific paragraphs, Second Amendment complaint. They are described as challenge statements and as factual basis for many of the allegations set forth therein, including detailed description of the specific alterations to the omission of trial testimony by defendants. The defendants knew the alterations changed the impact of the testimony, and it's evident that they made them for that reason, in order to continue to tell their story. This is further corroborated in the document productions by Netflix, which demonstrated involvement of Netflix personnel in attempting to make the story more dramatic and emphasize plaintiff as an alleged villain of the story. Sorry. Describe in detail the items of damage you contend sustain result of producer defendants' acts or omissions alleged in the Second Amendment complaint. Subject to his general objections, plaintiff responds as following. Making a murder damaged, if not destroyed, my reputation, my health, my personal life, my reputation as a police officer, so important to maintain as trustworthy and being with integrity as well as honest, was severely damaged as the millions viewed and believed the falsehood of that was making a murder. In the social media realm, my reputation was totally destroyed, as I was, and still am portrayed as a poster child for corruption. I began to fear that this annihilation of my reputation would affect the weight of my courtroom testimony in other cases, effectively ruining my career as a police officer. My health was affected as I did and continue to live in a state of constant hypervigilance, as making a murder prompted a multitude of death threats to me, towards my family, never being able to totally react, as well as constantly anticipating an attack on me or my member of the family, has caused me to develop both hypertension and anxiety, which, well, if you read his deposition, He clearly said that he didn't get prescribed any anxiety medication until a few days before his lawsuit was brought forward. But I'll continue reading. My personal life has also been greatly damaged as a result of MAM. My ability to go back to the person I was before MAM has destroyed my 30-year marriage, and the marriage ended in divorce. I have lost my family members and friends because of MAM's false narrative, reckless agenda, and portrayal of me, which is only extrapolated by the social media crazies who continually, 7 years after his release, claim that I am a corrupt, evil person and that MAM is truthful. I am often confronted by total strangers who inform me that they despise me for what I've done. Regarding Stephen Avery, I'm not allowed to present any media event, or my current employer or my presence could be disruptive. For each item of damages that you identified in Interrogatory 8, identify the amount of damages you are claiming and your method for calculating such amount. Subject to general objections, plaintiff responds as follows. Damages to your reputation prompted me to retire from law enforcement 4 years early than I had wanted to, costing me at least $400,000. The value of the damage of my personal life, destruction of my marriage, and the loss of friends and family, personal health and well-being, sense of calm and sense of safety and security, and general damage to my reputation. I'm requesting determine a trial by a jury. In personal opinion, I value of $1 million per episode of MA1 and MAM2 would not even cover the loss of personal happiness caused by. Yet defendants have undoubtedly been enriched by at least that amount through what they took from me. I identify all persons with knowledge of the facts relating to the damage you described in Interrogatory 8 and the substance of each person's knowledge. Number 10, response. Subject to general objections, plaintiff responds as follows. I have discussed the facts of the damages detailed in my response to Interrogatory 8 with very few people due to my newfound inability to trust anyone. I have disclosed those damages to my healthcare providers and to the law firms who represent me in this suit. I have also disclosed how MAM damaged me personally to the law firm representing me in my divorce case. I further have disclosed how MAM has caused my damage to the producers of an upcoming documentary entitled Convicted in Murder during interviews with them. Beyond that, I rarely, if ever, discuss how MAM caused me damages. I instead only defend myself. My fellow deputies, my former agency, and law enforcement in general, when asked and confronted about Netflix or the producers of MAM or myself. Number 11, identify every health care provider that you've seen or treatment for conditions that you believe was caused, which in treatment, the diagnosis you received, medications, prescribed treatments, therapy received, dates, treatments, therapy. Plaintiff designates he has previously produced healthcare records in response to interrogatory without having confidentiality designation said prior to production, which are incorporated by reference herein. Plaintiff further responds that he's been following providers that he has been seeing anxiety relating to the effects of MAM. Teresa A. Krugajunk, MP, Preva, December 28, 2018, noted having presented anxiety follow-up June 28, 2019. Plaintiff has been Buspar results in anxiety caused by MAM. Plaintiff believes that the stress is also adversely affecting his blood pressure, for which he takes lisinopril. Damages are ongoing, and plaintiff reserves the right to supplement this response. Signed by George Burnett. State of Wisconsin, County of Andrew Colborn. Here signed it. Well, he didn't sign it. Exhibit of summary, basis of knowledge, Avery quote, nobody said anything, obvious reasons, doubt, veracity, Avery convicted murderer who claims that he was framed, further accusations regarding civil suit settled for less than he was claiming, and the suit did not establish a liability for allegations made. Kim Ducat, dire warnings of alleged intended related to civil suit, obvious reason, doubt, veracity of informant, an Avery relative and sympathizer who offers apparent bias for her statements other than her own alleged intuition. Photo of plaintiff and other alleged county conspirators during following Ducat statements. Obvious reasons to doubt the veracity of informant. An Avery relative and sympathizer, yet defendants argumentatively build on comments by directly accusing plaintiff and scheming to retaliate against Avery through his visual of plaintiff. Time to concede, followed Ducat statements. Glenn lengthy comment accusing plaintiff of feeling threatened by civil due to alleged mishandling of 95 call. Obvious reason to doubt veracity of the informant. An attorney advocate for Avery in the civil suit who likely believes that he lost the prospect of a significant amount of additional fees that he could have recovered in the civil suit. Glenn, 1995 call setup and disruptions argumented by MAM Images plaintiff in statements by Glenn allegedly implicating plaintiff alleged cover-up of the call. Obvious reasons to doubt veracity of the informants. Avery, and an attorney advocate for Avery in the civil suit who likely believes that he lost the prospect of a significant amount of additional fees that he could have recovered in the civil suit. Yet defendants amplified aggravated Glenn's statements through their visually implicating plaintiff in alleged cover-up by selecting the cherry-picking excerpts from civil suit depositions that concerned plaintiff even when their witnesses were obviously speculating, juxtaposing Avery's comments and just claiming cover-up. Depositions claiming Glenn's accusations that there were unconsolable withholding of information, conspiracy of silence. Accusation by Glenn that plaintiff and others were in the most serious kind of trouble and allegedly hid evidence they did hide evidence. So that civil suit would allegedly motivate the plaintiff and others implicate in the Hallback murder. Not only did they hide evidence in his 1985 case, they also definitely, the Veely CD, we got all this Manitowoc audio. I always wondered, did that clerk that works for Manitowoc, does she still work there after releasing all that information that they claim they didn't have? County settlement reference, then Avery's heard alleging that they framed him, followed by Strang and Beauty making out-of-court statements in effect that officers planted blood in Hallback's feet, planted the Kirav key in Avery's bedroom. Obvious reasons to doubt veracity informants, Avery and his attorneys. Bates states that the county law enforcement scrubbed the RAV key and put Avery's D on it. And I believe that too, because his toothbrush somehow goes from sitting in the toothbrush holder to underneath his sink. And Jody's the one that found it. And she even questions him in a phone call and says, hey, why is your toothbrush underneath the sink? And I don't know. That's because Linker Colborn took it. Obvious reason to doubt veracity informant, Avery's advocate and attorney, yet defendants use visuals and tie accusations directly to plaintiff. Statements by Avery and his attorneys. Obvious reasons to doubt veracity informants, Avery and his attorneys, yet defendants include photographs and plaintiff to tie the accusations to him and timed the statements to be followed by edited testimony by plaintiff in trial, which specifically altered to make it appear. He acknowledged that his call to dispatch could be interpreted as established that he was looking at the vehicle when he made it. In effect, plaintiff did not testify, therefore defendants knew that the statement was false as if they had altered it. Obvious reasons to doubt veracity of the informant, Avery, Beauty out of court statements that the two police officers, maybe one, could have planted evidence and would have no fear of being caught, coupled with the image of James Link. Obvious reasons, doubt of the veracity of the informant, Avery's advocate attorney, yet defendants used visuals to tie accusations. James Link was also repeatedly in a series alleged to conspire with the plaintiff. Alan Avery's statements that law enforcement set up Avery by planting the key. Obviously reasons to doubt the veracity of the informant, Avery's father. Avery's attorney out-of-court statements that the key was planted, blood was planted, and tying it to those who were deposed in the civil suit, which they allegedly didn't tell. Avery's attorneys. Obviously, Avery's statement that a couple of them wanted to railroad me, coupled with plaintiff's photograph inserted with MAM. Avery yet defendants added visuals to tie accusations directly to plaintiff. Defendants again used imagery implicated plaintiff. Avery yet defendants added visuals to accusations directly to plaintiff. Base allegations of the conflict of interest coupled with strain and beauty of the court accusations led framing. Beauty referenced the closing argument to Link finding key, but MAM adds photograph and plaintiff with James Link. Obvious reasons to doubt. Avery's attorneys and defendants emphasized the arguments and augmented arguments by adding photograph of the plaintiff, and at which point the attorney will only reference James Link. Defendants can only alter viewers' impression, interpretation, and closing argument except for the placement of their visual. Cut to Ken Kratz argument referencing Link and Colborn. Placement of these experts and timing of sequence make it seem that Beauty in fact referenced Colborn in an argument expert directly preceded Kratz excerpts, which he did not. Defendants only altered viewers' impression and interpretation of the closing arguments experts through placement of their experts. Experts from closing arguments are strung together and misleading, suggests that even Kratz acknowledges that the police may have killed Halbach. Well, why does Kratz in his closing argument say, so what if the key was planted? Like, why the fuck would you say that? Well, that's because he's telling the jury that if you think that these officers planted this key, then you're saying that these officers killed Teresa Halbach. But Stephen Avery never made that accusation. He said they're framing me for her murder. But, yeah. Avery's attorney is out of court statements regarding impact of alleged Avery framing and possible audacity defense. Avery's attorneys. Season 1, Episode 1. Avery, they had evidence back then that I didn't do it, but nobody said anything. 2, Kim Ducat, they weren't just going to leave Stevie alone. They were going to hand that man $36 million. They weren't going to be made laughing stock, that's for sure. 3, they just weren't going to do it all that. And something in my gut said that they're not done with him. Something's going to happen. They're not handing the concluding plaintiff Andy Colborn testifying in background during the above expert, along with other alleged part of the Manitowoc County Sheriff's Department conspiracy. Season 1, Episode 2, Stephen Glenn, the day after Stephen's release, law enforcement officers in Manitowoc are writing memos to describe actively that they had occurred almost 10 years earlier than they do to unless they feel threatened. Stephen Glenn, we learned during the litigation something that they had obviously knowledge of before the lawsuit got started. The 1995 was a very significant point in that thing. Video deposition and plaintiff was shown in background. And there's not only something of this idea that the law enforcement had information about somebody else, but there's a serious meat on those bones. I mean, serious meat. When we learn that while Stephen Avery is sitting in prison now for a decade, a telephone call comes into the Manitowoc Sheriff's Department. Image report prepared by plaintiffs is shown in the background from another law enforcement agency, which at least one of the officers involved in the process believed to be Brown County Sheriff's Department, saying that they had someone in custody who said he had committed an assault to Manitowoc, an assault for which somebody was currently in prison. Glenn, you were gone over Exhibit 138. Plaintiff, yes, sir. It describes you receiving a telephone call in 94 or 95 from someone who identified himself as a detective, correct? Yes. The detective indicated that there was a person in custody who had made a statement about a Manitowoc County offense, correct? Yes. And that was the person in custody. He said he had committed an assault in Manitowoc County and someone else was in jail for it, correct? Yes, sir. Footage of Glenn speaking in the interview. Manitowoc doesn't have huge numbers of major assaults where people go to prison, and certainly where people would still be in prison. There's a very distinct possibility, I would say, that likelihood that Gregory Allen, graphic shown in the background depicting bullet point, developing timeline of status 1995, Gregory Allen is arrested for sexual assault in Brown County. Andrew Colborn receives call about inmate confession. It's the Brown County Sheriff's Department that is in 1995 on Gregory Allen case. The Gregory Allen has said something about Stephen Avery, and at the minimum, somebody ought to check this out. Back to footage of plaintiff's video deposition. Glenn, the significant event right there that was stood out of my mind. Go back to the interview with Glenn. Glenn, the fellow who got the call with the guy named Colborn, you might say that should be a record of him immediately making a report on this. There might be a record of him immediately contacting a supervising officer. There might be a record of him contacting the detective who handles sexual assault cases. There might be some record of it. But if you thought any of those things, you'd be wrong, because there isn't any record in 95, 96, 97, 98, 2000, 2001, 2002, 2003. So why did he skip 99? Return to the image graphics for the nursing room prior to timely image plaintiff's image above. The statement of 2003 that states DNA evidence exonerates Stephen Avery. Now 2003 is the year that's the meaning, because that's when Stephen Avery got out. And the day he got out, or the day after, that's when Colborn decided to contact a superior officer named James Link, and Link tells him to write a report. And then they're going to go have contact with the sheriff. Now let's just stop and think about that for a minute. Why does that happen? Why does that happen then, when it didn't happen 8 years earlier? I mean, I think I know the answer. I think the answer is pretty clearly these people realized that they had screwed up big time. Colborn realized it, Lincoln Superior realized it, and the sheriff realized it. So Link tells Colborn to write a report. The sheriff tells Link, get me the report. The sheriff puts the report in the safe. That's how much he cares about documenting this thing. Well, obviously, it doesn't do anybody, and certainly doesn't do Stephen Avery any good to document the 8 years after the fact, because Stephen Avery is still sitting in the cage for those 8 years. This falsely implies that plaintiff did not advise the appropriate person within the MTSO of a call when they came in 1995, and that Colborn believed that he had screwed up and raised the issue later in an attempt to cover up the failure to do anything in the call, when in fact plaintiff did transfer the call to the appropriate individual within MTSO. Footage of Lieutenant Link is testifying. Glenn, document didn't even begin to get prepared until after you had talked to Sheriff Peterson. Is that fair to statement? Lieutenant Link, correct. It indicates that Colborn said he was informed by someone in 95 or 96 that the case was already solved and the right person was arrested. True? True. Sergeant Colborn couldn't recall who it was who told him that it had already been solved. True? True, that's what he was told me. Did he make any guesses about to say, gee, it could have been this person or it could have been that person? I'm not sure. He wasn't sure. Switches to video deposition testimony of Sheriff Peterson, identified as Stevens' 1985 arrest officer. You recognize Exhibit 25? That's one of the Sheriff's Department statements forms, and it looks like James Link's signature on it. Okay, and you have seen this document before? No. Okay, and about 138, which is, well, you tell me what it is? Yep, another one of the statements from, looks like it was filled out by Andrew Colborn. Close to the top to play the signature of the form. And again, you have seen the document before? Nope. A lot of people told me to watch my back. Most of the time, I didn't even believe them. But then sitting and doing depositions, I don't know. I kind of changed my mind. They were covering something up, showing close-ups of the report prepared by plaintiff, and then they still covering something up. Even if the sheriff who's there now, he's covering something up. Have you ever had a conversation with anybody else other than Sheriff Peterson or Lieutenant Link about the subject matter, Exhibit 138? Ever discuss it with anyone else other than officers and friends and family? Not that I can specifically recall. I may have mentioned it to another people and don't recall doing it. Switches videotape reception to Mark Rohr, Manitowoc County District Attorney, Counsel. At the time you received information from the crime lab telling you that Gregory Allen was inculpated in the sexual assault, Mr. Bernstein, did you have a conversation with any people in the sheriff's office? Rohr, yes. Who were they? Andy Colborn, James Link, and information they had received. Let me show what's been marked as Exhibit 124. I'm familiar with the document. Who's Douglas Jones? Assistant District Attorney for Manitowoc County. All right. What is the memo? To your understanding. It speaks for itself. He had a telephone conversation with Jean Couchet about the case. The document reflects a conversation between you and Douglas Jones shortly after it became public knowledge that Stephen Avery had been exculpated and Greg Allen is inculpated, right? That's correct. All right. He says Doug Jones, was trying to close the conversation. You told him in 95 or 96, custody graphic showing plaintiff's photo under plaintiff, Sheriff Tom Kasurek. Andy Colborn had told Manitowoc County Sheriff Tom Kasurek that an officer from Brown County had told Colborn that Allen is not the Avery might actually committed the Bernstein assault. Okay, did you in fact tell Douglas Jones? I don't recall. Of course. All right. Does seeing his document on 24 refresh your recollection? My recollection of this conversation, which is not very strong, was that Colborn made a comment to me about getting some information. Okay, and statement goes on, says that the next sentence says Gene stated that you and Colborn told Kasurek something to the effect that we already have the right guy, and he told a non-concerned himself. Now, did Colborn tell you that to you? I don't recall. Do you have any reason to believe that Doug Jones would misrecord what you said or told him? Nope. Then it goes on to say that Doug Jones asked if the information was known. Do you remember him asking that? Nope. Then it goes on to say that James Link was aware. Did you tell Doug Jones? If you put in there, I probably did. And what was the basis for your knowledge about that? It would have had to been Andy Colborn. This is unconceivable withholding of information that could have been used to Stephen Avery's lawyers, who were right at the time in the middle of the litigation, asserting that based on the fingernail scrapings that there had been somebody else involved in this. If the information had come to light in 95, Stephen Avery would have gotten out in 95. So they cost Stephen Avery 8 years of his life. This is as close to conspiracy of silence as you think you could find in a case. Well, Kelly, do you provide information to the Attorney General's office? Mark Rohr, yes, my recollection said I believe we did. Kelly, and who's we? Mike Griesbach and I went to Madison, but this memo was drafted after you had been to Madison. I'm not sure the date when we were in Madison. You saying you told information to the Attorney General's office? We passed everything we had obtained to the Attorney General's office. Okay, well, neither this memo nor anything about Colborn and Link is any of the records that we provided to the Attorney General's office. I can tell you that. Noting footage, Manitowoc, including prepared background. October of 2005. For the respect of the Manitowoc County government and these defense lawyers, I believe they all knew that we're in the most serious kind of trouble, that they were a very grave prospect of very, very substantial verdict. Manitowoc County and the sheriff and the district attorney were arguably covered by insurance policies, and there's a good half dozen insurance policies. However, the insurers have taken the position that because of the nature of the allegations against the county, the sheriff and the DA, the policies do not cover, which would mean the Manitowoc County itself and the sheriff and the DA would be on the hook for those damages in the civil suit. Glenn, why do you not have somebody tell us that you're going to have an effect on the law enforcement? Of course it has an effect on law enforcement. Are you kidding me? I mean, law enforcement officers get uptight when they even suggest that they have something wrong in the courtroom. Imagine that they are going to say that you're a liar and you hid evidence and you deliberately prosecuted a person that they knew or at least had reason to know wasn't guilty of a crime. And putting all that aside, by the way, in terms of your own professionalism, the guy out there raping and beating women while the guy that you put in prison is sitting in a cell, how does that make you feel? We were just on the absolute edge of getting ready to go after named defendants in the case with depositions when I get a call from Walt who tells me that he's gotten a call from journalists asking if either of us would care to comment on an apparent intersection in the life between Stephen Avery and a woman who was gone missing in the Manitowoc area, who we later learned to be Teresa Hallbach. Timeline again displayed indicating dates of plaintiffs and other depositions proximity to Hallbach. News footage regarding Hallbach's disappearance, information 1999 dark green RAV4. No, I'm not even going to touch that one. News footage of Avery interview. Anybody can go down the road in a nightmare when everybody's sleeping and just driving. My brother ain't going to hear nothing. Reporter, so who do you think did something with her? Avery, I got no idea. If the county did something or whatever, or tried to plant evidence on me or something, I don't know. I wouldn't put nothing past the county. cutting the footage of Ken Kratz, press conference, the footage of police on the scene, spoken by Avery. All I can think is that they're trying to railroad me again. And I ain't been home. They ain't been searching. You know how hard it is to put evidence in the house or on the property. The sheriff was out to get me last time. How do I know he ain't got nothing to do with it this time? It's all come back. All these memories, everything else, everything just sketching me out again. And deep down, it hurts. You know, we're all victims, and they just won't leave us alone. They just keep it up and keep it up. You know, a person can only take so much, you know. Right now, I got enough of them. You know, they can go somewhere else and just leave us alone. Let us do our life and live normal. Avery, see if somebody else plants that shit there, you ain't going to see. How does your DNA get inside of her truck? My DNA ain't. That's because they got blood out of me. How much blood they got out of me? A lot of blood. Testimony of officers of court regarding key pictures of Colborn Link standing next to the other unidentified woman bar patron. I really don't think he was framed. You know, there's a lot of that points to where the sheriff department could have had something to do with it, and then don't know if it's true or not. But I also heard Manitowoc County was not supposed to be allowed into the search, and they were there and they searched, and that's who found the key. Apparently, after the third day, was Manitowoc County Sheriff's Department. So I mean, like I said, none of it really adds up. Identified man, bar patron. I only have one word from the cops up on up: corruption. I mean, big time. I mean, if people dig for far enough, they'll see that. Identified woman, bar patron. I don't care what anybody says. That's a lot of money to pay out for a Manitowoc County. It's a small area, and I really truly believe the county didn't have funds to pay it. Or somehow, some way, I don't care if they hate me. That somehow, some way, something got set up, and I don't care who it was, and they can say, oh, you really believe the Manitowoc County Police Department and the FBI and everybody came in, and they set this all up to just have Stephen Avery guilty for this thing? Yes, I do. Sorry, yes, I do. Avery this way, figure that they just got away with it. They can do it again. You know it. It ain't gonna stop them. Strang, I didn't see them plant evidence with my own two eyes. I didn't see it, but I do understand how human beings might be tempted to plant evidence under circumstances with the Manitowoc County Sheriff's Department found itself after Stevens' exoneration of the lawsuit and the Avery Commission and the government hugging Stephen and holding him up as an example of the criminal justice system gone wrong. Do I have a difficult understanding what human emotions might have driven police officers to want to augment and confirm their beliefs that they have killed Teresa Halbach? I don't have any difficult understanding those human emotions at all. Building so you have motivation of the officers who want to get him, and then when I want to low end, behold, there's a woman who disappears, and one of the last people that saw was Stephen Avery. Now we've got him. Aha, we knew it. They concluded he's guilty right off the bat, and now we thought we're going to make sure he's convicted, and they helped it along by planting his blood in a RAV4 and planting the key in the bedroom. Pete Bates, but that came up represented the only DNA found on the key was Stephen Avery's. That's particularly ridiculous. Any crevices, anything else that the key would have retained in the DNA. Even for them to be able to say only Stephen's DNA is on the indicates to me that the key was scrubbed clean and DNA was placed on it. Yep, with his toothbrush. Some might think, well, you know, and then they used the groin swab to plant it on the fucking hood latch. Our hands were tied, you know. Think you got a client who's saying he's being framed publicly. That's kind of the defense you better go with, or you're contradicting your own client. But it really wasn't that way here. Defense was raised because we think the evidence pointed that way. Here's what we saw. The RAV4, the victim RAV4, is found on the Stables Yard property. A ridiculous place to leave it if he was the killer. There was a crusher on the property. Second, his blood was found inside the vehicle, but only a few areas, spots, so to speak. There was evidence that he had a cut on his finger, but he didn't make sense that there was fingerprints of Avery's at all on in or on the vehicle. That would mean if Avery was the killer, he had to have gloves. But if he's got gloves on, how could he be actively bleeding and leaving blood behind? So I looked at to us like maybe his argument: if my blood is in the vehicle, somebody planted it there. Maybe the evidence was pointing that way. Brendan Dassey segments, beauty interview. Sheriff Peterson was the arresting officer in Avery 1985. He's now the head of the office and clearly has a strong dislike of Avery. If they're a very top guy, he has a kind of attitude about he also said that it'd be easier to kill Stephen Avery. Showing photos of the lower levels of which shown brighter colors stand out. Discussion of involvement link Avery's 1985 case. They show examination of the 1985 case file leading up to the blood vial examination. Beauty on the phone and strang. Let me tell you, this is a red letter day for the defense. It could not have been better. The seal was clearly broken on the outside of the box, and the inside of the box, the styrofoam kit. The seal is broken in that. We pulled the styrofoam halves apart, and there's, in all of the glory, was a test tube that is Stephen Avery's and inmate number. Everything on it. The blood is liquid, and get this, right in the center of the top of the tube is a little tiny hole, just about the size of the hypodermic needle. And spoke to LabCorp personnel who told me that they don't do that. They think about Dean and LabCorp didn't stick the needle through the top. Then who did? Some officer went into the file, opened it up, took a sample of Stephen's blood, and planted it in the RAV4. Somebody knew the RAV4 was there before they even went in there. I'm convinced of it. What about the cop? Tammy told me that. She told me that she heard that the cop put out there and planted evidence, but what out there? The vehicle, the Teresa vehicle? Yeah. Sammy told you, somebody told her that the vehicle, Teresa Hope. I'm going to highlight on that Tammy Weber. She claimed he was, talked to her the day he got arrested too. She tells him that she heard that somebody planted that vehicle on the property, and when officers go talk to her, she says that her son's friends said that they heard from a Two Rivers police officer that the car had been planted there. And the two boys are the Schneider boys. Their father's a police officer, and they don't go talk to the boys, they talk to the father. And the father claims that they were playing with the Ouija board, and that's where they got that idea. But back to Tammy Weber, after they talked to her about this allegation of the car being planted, they begin to question her, trying to get her to say something incriminating about Stephen Avery to paint him in a bad picture, just like they did everybody else. Jerry Bruni, one of the things that the state argued is that it would have taken a wide-ranging conspiracy of so many people to pull this off, and that there's just no way that it could be possible. But in fact, it's not true. Really, two people could have done this easily, even if they had motive to do it. Maybe one even. The whole argument, well, why would they risk doing this and risk getting caught? If you had understand the possibility, would no fear or even being caught doing this, who better than a police officer would know how to frame somebody? Or the best way to frame somebody is frame something that didn't happen. Then you can just make up the evidence, precisely what happened. Alan Avery, they had Stephen picked up as far as concerned right away. They set him up right from the beginning. They find nothing down by his trailer for 3-4 days, and all of a sudden stuff starts. Oh yeah, we found this and we found that. And the Manitowoc cops found the key. They weren't even supposed to be investigating this at all, right? According to what they said on Jerry Pagel said on the news. All they had to do was just remove Colborn, but it's not even that, because they were all on the property. Peterson, all of them. Everybody the only one that wasn't on the property is Jean Couchet. There's somewhere nearby. They're just waiting for the right time. We can do it. That key does not fall from you, between the backboard and the frame of that little bookcase. No, and find its way underneath a pair of slippers. And if we get them thinking, look, the guy's capable of planting a key, who's to say he's not capable of planting blood? Blood's easy. Yep, blood's easy. Yep, blood's easy. The bottom line is that they knew their boss had just recused the department and turned over lead authority in the investigation to a neighboring department because of the lawsuit. They were opposing the lawsuit. They didn't tell you no. Cut out the footage of Link, Colborn, Strang, the alleged interest. They can cut the footage of Avery mother cooking with subtitle audio Stephen Avery's talking. Avery, I'm in the same situation that I was before. Just a couple of them want you to nail me, and the other ones didn't. Nobody speaks up. I got to through this over and over. 49. Avery continues. Sometimes I wonder if I don't know. Just hard to take it all in. Switching to shot of plaintiff standing in a courtroom. Avery appearing to look at plaintiff and looking sad. Then a segment with Kratz examining plaintiff in court. Strang. Pete Bates. Manitowoc County Sheriff's Department had, by their own admission, in fact, that the first ones they brought up that there was a conflict of interest there. Greg Shetter is the one that allegedly brought up the conflict of interest to Jerry Pagel. And a conflict of interest investigation crime lab, probably the most serious violation any investigation agency can make because it brings into question the credibility and actions throughout the case. And if I had to guess, I would say that declared it to conflict. Hold on a second. Interest across D's, not cross I's, dot I's and cross T's. They didn't implant to produce the would follow conflict of interest and the quote simply to totally back off. They continued their effective role in the investigation. They developed most of the evidence when they took on the role that they shouldn't have. They also committed themselves to proving Stephen Avery had committed the crime. Reporter Sergeant Colborn was up there from quite some time today. There's a gentleman who I think had been a law enforcement officer for 13 years. He puts on a uniform and a badge and a gun every day and goes to work and tries to do his best. We're all here. We're putting this on TV. This guy's going to go home and listen to his son maybe cry about how everybody in school made fun of him. Yeah, okay. But my question is, though, if you were going to put somebody on the stand, accuse that person of conspiracy, Mr. Kratz kind of made it sound like you should have been able to offer some proof that planting actually took place. You're hearing the evidence of a conspiracy, and I've sat in many federal courtrooms and heard federal prosecutors provide conspiracy on less than what we've heard already here, and you will hear by the end of this trial. Examination of Fassbender regarding signing sheet, scene, and examination of Link, which is footage, every phone call with his mother. Another strange thing about Fassbender and Dave Remacher, somebody signs that Dave Remacher was in a search into the garage and trailer when he wasn't even on the property. Breeding, speaking on his car. Look how quickly they got the FBI to retool their instruments and recalibrate everything. Do these internal validation studies. They're going to claim I can get results within a matter of weeks, a few weeks, on the tests they have done for 10 years, and yet the crime lab has, in 2002, evidence that his lab that Stephen Avery is innocent, and it sits for a year before it gets tested. It shows that the imbalance between the individual and the power of the government. The full force of which they're trying to bring us to bear on this man. Why? Why in this case? Because we have accused, and the evidence suspiciously points to framing by one of them, and when you do that, you do so at your own peril. And that's the state would say, Again, it's not like they think they're framing an innocent man, but they are. This could be done by two officers, really one officer. The one officer who's coming up, Lieutenant Link, whose name's on the evidence transmittal from the 1985 case, just a couple years earlier. Lieutenant Link, who shows up on November 5th without logging in. Lieutenant Link, who finds the magic key. Lieutenant Link, who 4 months later, 4 months after Manitowoc no longer is needed, with no legitimate reason is back at the scene on March 1st, and that's what found the next day. That's what I've always said. If you look at the sign-in sheets from March 1st, after Brendan's false confession, the coercion, and you look at the names that are in the initial search from November 5th until the 12th, and you match the names, that's who's involved. Just two guys, Jim Link and Andy Colborn. The livelihood, their reputations, their families, everything in their 20 plus years of law enforcement are on the line. When some lawyer accuses them of misconduct, not just misconduct, but planting evidence in the murder case, and this vile planting offense, absolutely ludicrous, would only had to call one witness who significantly could tell you that there absolutely no way the vile blood was used to plant. Would Lieutenant Link lie? Would he lie as sworn law enforcement officer? Well, so you can tell if he has lied. He did twice, and you heard it. Yeah, he lied in trial, and still the jury ignored it. He says he arrived at 2 when he asked under oath before it's 6:30 or 7. Then it's 15 minutes off, folks. Under oath, and it's a difference of 4.5 to 5 hours. At the time of the year, November 2005, it's the difference between broad daylight and pitch black. He was under oath, and when police officers plant evidence, they are not doing it to frame an innocent man. They're doing it because they believe the man is guilty. They're not doing it to frame an innocent man. They're doing it to ensure the conviction of somebody they decided is guilty. If you buy Mr. Strang's argument that they were trying to make sure that the guilty person was found guilty, then assigning this accountability to the murder of Teresa Halbach shouldn't matter whether or not the key was planted. In other words, you can say to decide there's enough evidence, or is the key the only thing that points to Mr. Avery? That key, in the big picture, and the big scheme of things, means very little. Why do you not never have claimed that the police killed Teresa Halbach? However, the person or persons who did knew exactly who the police would really want to blame. Kratz, despite Mr. Beauty standing up here saying, look, folks, we're not saying that the cops killed Teresa Halbach. That we're saying that somebody else skillfully exploited the law enforcement bias, as if there's somebody smart enough out there that they could do that. But when you scrape one layer of the manure off the topsoil and you realize that the cops had to kill her, now are you, as a jury, in order to find Mr. Avery not guilty, willing to say that your cops, the Manitowoc County Sheriff's Department, Lieutenant Link, Sergeant Colborn, came across a 25-year-old photographer, killed her, mutilated her, burned her bones, all to set up and frame Mr. Avery? You've got to be willing to say that. You've got to make that leap. Well, if they frame Stephen Avery, the question is Brennan case a whole charade too? I mean, that's ultimately going to be the question. Exhibit 8 summary. Yeah, I'm not going to read all this. We just... missions. Alright, MEM take testimony out of context, order drama, make different defense cross-examination of the plaintiff look more devastating, to make direct examination of the plaintiff to look more scant and absent of detail. Kratz, did Mr. Avery have a response for you? Plaintiff, yes, he said that she had been there. Kratz, did he tell you what day she had been there? I think you might have told him that. What day she would have been out there, I don't recall if mentioned a date, but I remember asking him what time she had been there. Did Mr. Avery recall the young woman? Yes. Did he name her for you? No. Did he tell you what she had done at his property that day? He said she was there, was taking some pictures of a van that her sister was selling. Mr. Avery tell you how long the van had been on the property? He said 5 or... Mr. Avery tell you how long the van had been on the property? He said 5 or 10 minutes. I don't think this is correct But I can. That van been on the property a long time because in September of 2004, he right before his lawsuit comes out. No, it might have been August. Yeah, it was August. No, it was September. September 17th. He's on the news and he's actually working on that actual van. I asked Avery if he had said where she was going. He said I never talked to her. She was only there 5 or 10 minutes and she left, but he never talked to her. That's what he told me. He never talked to her. That's what he told me. He never talked to her. Let's move on to the 8th, which would be Tuesday, the November 8th, where you asked to return to the property. Actually, he radios in on the 7th and says, hey, take me off the schedule for tomorrow because I'm going to be needed out here back again on the property. And another fun fact, the morning of the 7th, they were planning on wrapping up and ending their search and closing everything up. And then Cuss Road happens. Michael Bushman is... Dennis Jacobs is the one that is sitting on Cuss Road when Michael Bushman states that he sees a Manitowoc officer sitting at the end of Cuss Road, but he doesn't know who's sitting in it. That's why Dennis Jacobs' name is crossed out of the Cuss Road checkpoint, because he was there before they set the checkpoint up, but he surely left. But why'd they cross his name out? And then Bushman signing in, and then never signing out, but then signing back in, and then never signing back out, and then signing back in. And he's only there for one day for a total of 9 hours. Sergeant, do you recognize this image? Do you see the image of 8th of November? Kratz, can you describe the moment or the event for the jury, please? As I mentioned earlier, Lieutenant Link had exited the door coming into the bedroom. He had gone through the door to get a bigger container. I was searching the desk here. Deputy Kucharski was sitting on the bed, which also isn't in the photograph, but it's a very close proximity to the piece of furniture, the bookcase, filing out the paperwork. Lieutenant Link got out right, and here's what would be right here. This is just, I really don't want to read all this. This is just trial. It's everything that's in making a murderer. I was morally interested in the depositions. I am going to post a link to this in the description of the video. But there's a whole shit ton of more documents to go through because, well, this is just transcripts of testimony from the trial. But, Exhibit 49, plaintiff Andrew M. Colborn, supplement response, defendant, target attorneys, plaintiff, blah, 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 blah. And that's, and then we got, yeah. This is all just summary of everything that went through. Okay, that's the last page of that. So, let's see. This was document 279. So I still have what we just read is everything that's listed right here. And that was 279. So there's 280 and it goes all the way up to 294. So I don't know. It's 6 o'clock in the morning. I gotta be to work in like 6 hours. Y'all have a good day. I'll see y'all next time. And I will continue reading the other, what is it? 15 documents, Some of them are small, but I'm interested in, well, all of them. This is going to cost me a pretty penny, but it's all worth it. See y'all next time.